Good morning.
Good morning. May it please the court, I'm David Moss of the Chattanooga Bar, and I represent the appellants here, the plaintiffs below. I would like to reserve 3 minutes for rebuttal.
Okay, Mr. Moss, on the side of the appellee, there will be 2 arguments. Have you already divided your time?
Yes, Your Honor. Ms. Roberts is going to take 8 minutes. Start with 7. Thomas is
Thank you.
35, I don't have a different interest.
Thank you very much. And
Thank you, Your Honor. You're undoubtedly familiar with the facts of this case. The plaintiffs are the creditors of the estate of B. Allen Casey, Jr., and the defendants are the fiduciaries, court-appointed fiduciaries, the personal representatives of his estate and their associates. Allen Casey died owning a spousal elective share worth $6 million. And upon his death, the right passed to the personal representatives of Allen's estate under TCA 31-4-105. There were no viable defenses to the recovery of this. The recovery would render Allen's estate solvent, able and benefit the distributees, the creditors and distributees, not electing it to be wildly insolvent, and those interests would not be protected. Nevertheless, the PRs in this case, I hope you don't mind if I call them PRs, the PRs in this case, first, Ms. Casey, PR Casey, who was the administratrix of the estate, and later PR Exum, who was the administrator ad litem that was appointed, refused and failed to make the election. They forfeited the $6 million right. It caused $6 million damage to the estate, and it has damaged the plaintiffs to the extent of the debts that were owed to them. Now, in the limited time that we have for oral argument, I want to focus on issues number 1 and 2 that we raised in our brief, which are, I think, the decisive issues before the court. I don't think we can get to every issue that's involved in this case, but the first issue is fairly straightforward. In the PR's administration of the elective share right, which was a chosen action, which they had a statutory fiduciary duty to administer, were the PRs governed by the long-established common law fiduciary duties to administer it in the best interests of the estate? Or did the PRs owe no duty to anyone and have total discretion to harm the estate and enrich themselves, as the trial court held? And the answer to that question is, of course, their administration was governed by common law fiduciary duties. They're the fiduciaries for the estate. They owe statutory fiduciary duties, which y'all are well aware of, to marshal and collect and protect assets and to enforce chosen action, to pay the lawful debts and expenses of the estate, and then to pay the distributees. And those statutory duties are governed by their common law duties to act in the best interests of the estate. And y'all know what those are also. The duty of undivided loyalty to the estate. No self-dealing. No helping out somebody in another estate at the expense of your own estate.
Counsel, excuse me for interrupting. With reference to the statute, the language, the personal representative of the decedent's surviving spouse may, in like manner and every respect, make the election. That phrase, in like manner and every respect, what does that mean?
That means that the PR can obtain the same elective share by going through exactly the same process as Allen could have, by making the petition to the court in the same manner. That's what it means. It means they can obtain for the estate the same thing that Allen could have obtained for himself. The difference between the two is that Allen was not under any duties, and this was being specifically given by the statute to the personal representative who is under duties. There's a distinction here between giving someone discretion to do something and altering the duties under which that discretion is exercised. In this case, the discretion, we don't deny that discretion was given to the personal representatives. But what the statute did not do was to alter their duties. And I'd like to just point out that the trial court, for example, said that the words "every respect," that was what the trial court seized upon as the phrase that meant that it substantively not only transferred the discretion, but it transferred the duty. That, in other words, it transferred Allen's duty or lack of duty to the PR, abolished the PR's common law duties. They seized upon that. Well, I would just point out that if I gave you my power of attorney, I would give you I would be giving you a general power of attorney. I'd be giving you the right to stand in my shoes and to do in every respect what I could do. I give you the right to handle my bank accounts, to write checks, and you can write checks in any way that you want to. You've got complete discretion on that. I've given that to you. But by giving that discretion to you, I didn't change your duty that you have to, whatever decisions you make and whatever checks you write and however you handle my bank accounts, you have to do it in the best interest of me, the principal. And that's what we're saying here, is that when this transfers discretion to the PR, it doesn't change the duty. And the statute
what
does
is the
not say so.
point of the elective share? What's the purpose of allowing a surviving spouse to take an elective share?
Well, when the spouse is alive, for the spouse's benefit. When the spouse has passed, for the benefit of the spouse's estate. Now, this is something that we mentioned in our brief, where they cited, they cited other states where this has been actually discussed, and the court came to the conclusion that the transfer of the spousal right to the personal representative was expressing intent of the legislature to pass his interest in that estate that he had earned during the marriage. And this marriage, of course, lasted 57 years. We'd say that that's exactly what the purpose is of this statute as it is now written.
But during the course of his life, if he elects not to exercise that, will that still place a burden on the representative of his estate after he passed? Will they have a higher duty than he had?
They would have they have a different duty. They have a higher duty than he does. But let me address that. Now, we don't know what Allen would have done in this case because nobody told him about it. Nobody told him he had an elective share right worth $6 million. So we don't know what Allen would have done.
What was the period of time from the death of his spouse to his death?
It's a 2-month period.
2-month period.
From May to July. Mm-hmm. And during that time, he didn't waive his rights and or do anything to impair his rights. Now, what he is, of course, has latitude to do what he wants to while he's alive with that right. But when it passes to the estate, and I would say to Your Honor, that's true of many rights, many properties. He has total autonomy over much of his property and rights that he has. He can enforce them, not enforce them. He can waive them. He can do whatever he wants to. But the PR can't do that when it gets passed to the estate. When it gets passed to the estate, the PR has a different hat. He has different duties and responsibilities than the surviving spouse or the decedent had during their lifetime. And that's all that we're trying to say here, is that that didn't change here. And the language of the statute doesn't change it. It doesn't expressly get into it. If the court wanted to abolish common law fiduciary duties, it could do so. All it had to do was say, in the exercise of in the election regarding the elective share, the PR is not bound by his common law duties to act in the best interest of the estate. End of story. But I would like to point out that The Supreme Court has referred to these duties as sacred duties. Well, that puts it in a religious context. I mean, the fiduciaries are in a position of enormous power, and they have an opportunity to do terrible harm to the estate. And the only reason that a personal representative exists is as a court-appointed fiduciary for the estate. That's their whole reason for being. And they're in a position to do.
Excuse me
I'm
for
sorry.
interrupting. Is this statute in derogation of the common law?
Does it?
Is this statute in derogation of the common law?
It would be if it was construed as abolishing common law fiduciary duties. If that's the, I don't know if I'm answering your question. It would be in derogation of their common law. If it's interpreted to be to abolish their common law fiduciary duties with respect to this right of election, it would be in derogation of common law. Now, the Supreme Court's talked about this as being sacred in character because of the issues that are the enormity of what's going on. And I think what the court means by that is they're putting the fear of God, if you will, into fiduciaries. They ought to be entering onto their job duties, with awe and humility and respect, and they should be supremely conscious of the burden that is upon them, the enormity of the trust that's been put on them, and the burden that they have to always act in the best interest of the estate. And they should feel that burden the whole time that they're acting as a fiduciary for somebody else.
All of that is 100% true with respect to how the fiduciary administers the assets of the estate. I think the challenge is a discretionary decision that the spouse has, where the spouse can either, if they're alive, take it or not take it. It's not an asset when the spouse is alive.
No.
But you're saying somehow it becomes an asset just by nature of the death, even though the statute says you, PR, are stepping right into the role of the spouse. You have the same duties, the same responsibilities. I feel like what your argument is creating a change in the nature of the elective shares that is not recognized by the statute.
I think that the statute in passing the elective share to the PR, I would draw from that the intention of the legislature that the statute, that it would then be used for the benefit of the estate. That's the reason that they give it to the PR instead of anyone else. Those words have to have meaning also. I'm at the end of my base time. If you would.
You have finished your point, though. We asked you questions, so you have finished your point then. You finished your point, your initial points, right?
Well, I would like to just point out that
I was going to give you a minute just to make sure your point is finished.
I just want to say, interpreting the statute, you got to interpret it in the context of how important these duties are, and reading out your duties is a dangerous thing to be doing.
Okay, thank you. Yes, sir. Stelly.
Good morning, Your Honors, and may it please the Court. I am Sam Elliott of the Hamilton County Bar, and I represent Elizabeth Casey, Lynn Casey, and the late Mr. Carter Patton as individuals. My friend Mr. Thomas here represents Miss Casey, Miss Elizabeth Casey, as the personal representative or the executrix of Mr. Casey's estate. And as I said, we have 7 minutes for me and 8 for Miss Roberts. The court's asked a lot of questions that I was going to go ahead and respond to, so I'll try to be brief here if I can. This statute provides for an election, and it's important to note that the appellants have cited no case that imposes a fiduciary duty on the exercise or not of this statutory election. There are 4 concepts which all conveniently start with P. Judge Frierson hit on the first one. What's the plain language of the statute? And the plain language of the statute, just like the trial court found, says may in like manner and in every respect, referring back to the power of Mr. Casey, the late Mr. Casey. personal representative can make that election in the same way he can or decide not to, as the case may be.
Mr. Elliott.
Yes, sir.
The personal representative, do the personal representative gain, is placed in a position to gain if the election is not made? And the other question is, who appointed the personal representative? I'm interested in whether or not the personal representative serves one master or two.
Well, it's our position that the statute gives her the same right as Mr. Casey had. And so, yes, they're in a position to gain. And the cases make it clear. We both sides have cited the Murphy case and the McElroy case. If you remember the Murphy case, it was a situation where a man made an election on behalf of his mother against the estate of her deceased spouse and got control of a family farm that had been in the family for many, many years. And the Court of Appeals said, you know, that's the way the law is written. We don't have to look at the equities of things anymore. And that's how the way the law is written on that. So the answer to your first question is yes. But the answer to the second question is, in a way, as a result of a motion that they filed in the probate court, our clients were taken off as the personal representative, and the decision was ultimately made by Ms. Exum, who did not personally benefit from this. She was just, in fact, she personally did not benefit because she got sued for making the choice that the probate court asked her to make. So another concept that's appropriate to mention is the personal right one that you mentioned, Judge Davis, and that's provided for in the Haynes case, and we've cited numerous cases, especially bankruptcy cases, which relate to the fact that this personal right does not become a part of the bankruptcy estate, and you can read that right into the estate of the decedent without until it's made. Until it's made, it's just a right. And a personal right is not an asset. It's something that you have by means of your status as a person, and not a species of property. Again, Judge Davis, you seem to be on hit the other P on this because you asked for the policy of this statute, and the policy as announced by the Haynes case and as recognized by the Pritchard Treatise is that this statute exists to benefit the decedent spouse. It doesn't exist to benefit third parties. It's there for the spouse or their family, as the case may be, whoever the election is made on behalf of, or not, as the case may be. And a lot of families use in their estate planning whether or not you want to take under a will or you want to take under the election. To be frank, I would be surprised if Mr. Casey would have elected to do that because he wanted to not have to have his children pay off his creditors. And that was a bit of estate planning that he's entitled to do. And then finally, as I mentioned, the probate aspect of it, the fourth P, again, they made a motion. The probate court took it out of our client's hands, and it was put in the hand of a disinterested person who made the election or not, made the determination on the election. So unless the court has any further questions for me, that's...
I hear none.
Thank you.
Mm-hmm. Yes, ma'am.
Good morning. May it please the court. Lauren Roberts on behalf of the co-appellees, Jennifer Kent Exum and Chambliss Bonner Stoffel. As the co-appellee, I have the privilege, I guess, of covering some ground that has already been somewhat plowed. So I apologize in advance, Your Honors, if I cover some things that have already been covered. But I want to draw this court to the role of Ms. Exum specifically in this case, and that was as an administrator ad litem, and that was as an administrator for a very specific purpose, and that was pursuant to the order of Chancellor Atherton, the purpose of deciding very specifically whether an election should be made under Tennessee Code annotated 31-4-105 on behalf of Mr. Casey. Ms. Exum was not an administrator for any other purpose under the estate of Mr. Casey, and any attempts, and this is important, any attempts by the plaintiffs, the appellants in this case, to shift or to extend those duties that Ms. Exum may have had are problematic, and they shouldn't be given any credence by this court, and they certainly were not by Chancellor Fleener in her order, which we would urge this court to enforce and to affirm. In Chancellor Fleener's ruling, she looked to two specific issues, and I do think that those are the two specific controlling issues in this case that we have also briefed extensively, and that would be whether or not the election itself is an asset of the estate. And as Judge Davis has already recognized, that is something that is a question that we would urge the answer to be no, it is not an asset of the estate. And the second being whether there was some type of mandate on Ms. Exum in her role as the administrator ad litem to elect against the will. This order, this mandate that the administrator ad litem is urged to have based on the plaintiff's, the appellant's argument. They say in their briefing that they've never made such an allegation, that there is no mandate, that the statute gives discretion, it just didn't give discretion in this case. And that goes absolutely against everything that they have said in both the complaint and in pre-suit filings, or pre-this suit filings, and things that may be considered as part of the record, even though we're on a Rule 12 motion. Their protestations.
Let me make sure I have this correct.
Yes, sir.
The administrator ad litem was appointed for the specific purpose of determining whether or not an election should be made.
That is correct, Your Honor. As part of the record in this case, attached to both the original complaint and to our motion to dismiss, because it was something that was referenced extensively in the complaint itself, and thus is something that could be considered for a motion to dismiss without it being converted to a summary judgment. Chancellor Atherton's original ruling, the transcript from the February 3rd, let me make sure I have the date correct, February 3rd, 2021 evidentiary hearing, that transcript from that ruling and the order of appointment both specifically discuss the purpose of appointing Ms. Exum to be the administrator ad litem. It states in the ruling on page 10, she will be appointed for the limited purpose of making a determination as to whether or not an elective share should or should not be presented. And it discusses at length in earlier pages of that ruling the specific language of their 314105. There's emphasis by Chancellor Atherton's on the words in the statute, not shall, not must, but that the elective share may, quote, may, in like manner and every respect, be made on behalf of the deceased party, the deceased spouse. Chancellor Atherton specifically found, and this was information presented to Ms. Exum when she was appointed as the administrator ad litem. Chancellor Atherton specifically found that it was not a mandatory election to make. Despite this ruling by Chancellor Atherton, despite this, in the appointment of Ms. Exum, in the papers that were exchanged prior to her making her written finding that the election should not be elected, Ms. Exum had an opportunity to speak with the counsel for both the Caseys and counsel for the creditors, Mr. Henry and the other creditors, and there were threats made in those letters that this was a mandatory election, that Ms. Exum did not actually have any discretion, and threatened this very suit that we're in currently if she chose not to make the election. This mandatory election that the plaintiffs continue to assert, the appellants here continue to assert, does not, there's no precedent for it in Tennessee law. There are limited cases interpreting 314105 and its predecessor statutes. We've discussed at length here this morning in our briefing, really the three cases that exist on this matter. The Haynes case, McElroy, and Estate of Murphy. The Haynes case remains good law on this issue, and that states that there is discretion in the decision, and that's the discretion that was exhibited and used by Ms. Exum, still working within the limited fiduciary duties that she had as an administrator ad litem, an administrator for a very specific and limited purpose, so not fiduciary duties to the estate or its creditors or anyone else on a whole level, not these expanded fiduciary duties that the plaintiffs would try to put on her in that role, but that limited amount of fiduciary duties. There's discretion within that under the Haynes case, and McElroy and Murphy do not disturb that key holding. Beyond that, I would urge the court to look at the secondary sources, which have been discussed generally here this morning by both of the previous counsel who have spoken. Those secondary sources being the law of other states, including Missouri and Indiana, which have held that similarly to what we are urging this morning, that the personal representative in making an election may be they use their discretion, they use their best interest, and that's the best interest for purposes of the best interest of the surviving spouse during his or her lifetime, not for purposes of enriching the spouse, the estate of the surviving spouse or her heirs. That's also the rule that's discussed in Pritchard. Similarly, Corpus Juris Secundum discusses that the creditors of the estate have no right to control the election, nor may the creditors compel the election. And that's the very issue that we are here on this morning. That's exactly what they're asserting this morning. I see my time is running out. Unless your honors have any further questions, I'd ask that the ruling of the trial court be affirmed, that Ms. Exum be dismissed, and similarly that Chambliss, Bonner, and Stoffel with vicarious liability only also be dismissed.
I hear no questions. Thank you very much. Yes, sir. Your rebuttal.
Thank you, Your Honor. I'll make these quick. Mr. Elliott said that we had cited no case showing a fiduciary duty. We've had hundreds of cases, well, dozens of cases, talking about their fiduciary duties on PRs. They've shown no case that shows an abolition of fiduciary duties, that this statute abolishes fiduciary duties. Like manner in every respect, like I said, a power of attorney does exactly the same thing, but it doesn't remove duties. Those words do not mean an abolition of duty. I want to point out that the statute did not sever the fiduciary relationship out of which the common law duties arise. And and as long as that relationship exists, those common law duties exist. Now, to get to this, what is the background of the purpose of the statute? In the Haynes case, I want to point out a couple of things. First of all, it's characterized a personal right as one that cannot be passed to the representatives or to the heirs. But the legislature did pass it. It's now no longer a personal right. It's being passed, and it's being passed to just who you'd expect it to be, to the personal representative who owes the fiduciary duties to the estate. So that's exactly who you would expect to get it. And if that was not the case, then the Murphy and McElroy cases would have been decided differently, because in both those cases, you had PRs who just blatantly said, I'm doing this in the best interest of my estate, and I'm not acting in the best interest of the decedent during his lifetime. I'm not acting in the best. I'm not trying to do what would be equitable to the first estate. I'm not worried that I'm benefiting the survivor's estate at the expense of the first estate. The court said, you can do that because you have that discretion And he's expected, see, the implicit in those decisions is the expectation that, of course, he's going to act for the best interest of the estate. Now, I'd just like to close by saying letters ought to mean something. Ms. Casey sought out her position with she got the appointment, and her purpose was to not make this election so that she could enrich herself. And she got the appointment and did just that. Her letters meant nothing to her. Ms. Exum is defining her duties so narrowly that she has no duties to the estate. That's exactly what she said. She's got letters to represent the estate, but she's got no duties to the estate. And we say that those letters had meaning, and they mean that she has fiduciary duties with respect to this. We say that this chosen action was an asset of the estate. We will rely on the brief on that. I just say that we think every one of our claims is viable, and we think this court should reverse the trial court and dismiss reverse the trial court's dismissal and reinstate the complaint and remand the case for discovery and trial.
Thank you very much.
Thank you very much.
I want to thank the attorneys for your presentation. Your case has been submitted to the Court of Appeals, and you should receive our opinion and judgment within a reasonable period of time. Thank you all, and you may be dismissed. Madam Clerk, will you recess the court until after lunch?